The district attorney in the Alec Baldwin involuntary manslaughter case has responded to his motion to disqualify the special prosecutor. And after reading the motion by the defense and the DA's response, this issue raises very interesting and open legal questions to consider. So let's get right to it. Welcome back to La Belle Vie, our law and crime content. My name is Carol. I've been a lawyer for over 25 years, and I welcome you back to my channel. So I'm going to start first with Alec Baldwin's actual motion to disqualify the prosecutor, and then we'll follow it with the prosecution's response. Okay, so let's get started. So, taking a step back, the district attorney had previously requested and received funding for a special prosecutor in this matter. And the reason was that her office was very busy. They weren't going to be able to take on a significant case such as this with multiple defendants. And so, therefore, she requested and received permission to use a special prosecutor. So, that special prosecutor is Ms. Reed. Now, the interesting wrinkle is that Ms. Reed actually had ran for and won a seat in the New Mexico House of Representatives in November of 2022. So now she is a current member of the legislature, of the state legislature, but she's also the special prosecutor. So Alec Baldwin brought this motion to disqualify her as a special prosecutor using a separation of powers argument. And that being, in other words, the argument being at a very simplistic level, if you're a legislator, that means you're part of one branch of government, you can't at the same time act as a prosecutor or a special prosecutor, which the defense alleges is part of the, well, executive or judicial branch. They're not quite sure which. But in any event, and that's part of the open issues that we'll go through. But in any event, that's their allegation, is that she's part of both branches. Separation of powers under the New Mexico Constitution dictates that can't happen. And therefore, therefore, court, you must disqualify her. Now, the interesting thing here that they say, and this is a tactic in litigation where, you put your strong arguments first, you kind of hide your weaker arguments, and then you end strong, right? And so you start strong by here saying that her continued service as a special prosecutor in this case is unconstitutional. That's their argument. The legal question is not a close one. She must be disqualified. Well, that's their argument. But then the entire motion goes on to say how this is not a close question. It's an open question, and it's a really interesting question. Okay, but I just thought I wanted to point that out. But in any event, a very good writing. I mean, obviously, both motions in this matter were very good lawyering. So I'm really excited about this. So to go on, basically what they say, as I mentioned, is that because she is representing, she's now a representative in the legislature, she can't be a special prosecutor. And so here, that's where they say that. They say it's unconstitutional, therefore, for her to hold this role as a special prosecutor if that special prosecutor role confers on her proper power properly belonging to either the executive or the judicial. So that's part of the separation of powers. You can't have a single actor doing both. You've got to separate the branches. And what they say is that now the question is, well, what is a special prosecutor or a district attorney? What branch do they belong to, right? So they said that they start with saying that the New Mexico Supreme Court has held that a special prosecutor is basically the same thing as a DA because they hold all the same powers and duties. So, okay, so we accept that argument that the special prosecutor and the DA, who appointed her, they're one and the same as far as authority, legal authority, right? Now, one thing to back up, a district attorney is different from an attorney general, generally speaking, and that definitely is the case in New Mexico. An attorney general is the top lawyer of the state, and it's generally an elected position. But in any event, That's what we're talking about here. We're talking about the local district attorney for Santa Fe. So they go on to describe that power of the district attorney slash special prosecutor is either executive or judicial. But here's the crux. Neither the New Mexico Constitution nor case law is clear whether a DA exercises the power of the executive or the judicial department. And then they go on to say, on the one hand, the DA is part of the judicial section of the New Mexico Constitution. But then on the other hand, it's common that prosecutions are generally done by the executive office. Then they make this reference, and of course, the attorney general, who's clearly an executive officer. But again, remember, those are different positions, but they're trying to say, look, it's like the AG, that's clearly executive. So this DA and the special prosecutor are also part of the executive branch. Okay. So they've got to tie the district attorney and the special prosecutor to a branch of government so that they can make this separation of powers argument. So, but what I thought was really interesting here is that they say, okay, so we got to figure it out, right? Well, we don't know. They say we don't know. But then they say, but it doesn't matter. Because they say, but whether a district attorney exercises the power of the judicial department or the executive department is immaterial. That's where they lost me. But in any event, I'm not sure why that's material. I think you have to show they're one or the other or both, I guess. You can't be both. That would make no sense under the separation of powers argument. So you can't just say they're immaterial. You gotta tell us which one it is. So they basically kind of cursory, like very conclusory, make that argument. In my opinion, again, not legal advice, just my opinion. But super interesting, right? What is a district attorney? So they go on to concede that there doesn't seem to be any case law or precedent in New Mexico, excuse me, to kind of talk about what happens in the situation. And there's no case that we can find where there's been a situation like this, where a New Mexico state representative has simultaneously served as a prosecutor. So what that says is that this is a case of first impression. Okay, we don't have any precedent. We don't have any precedent in the case law. We can't find any other situation. So we're kind of like open here. So that's a lot different than saying what did they say? The legal question is not a close one. And then basically go on to say that there's no case law and no precedent for, the situation. And it does not it's not really addressed on point. And it appears to be the law in New Mexico, whether it's statutory, case law, or the Constitution itself. So super interesting. So they go on to, of course, they admit that there's no case law. So then they look to another state, which they look to Nevada. So taking a step back, for them, we're in New Mexico. And so for them to use another state Supreme Court's precedent in a similar circumstance is something that we call persuasive authority, but not binding authority. So it's persuasive authority. And what that means is that anything that you can use to show the judge where there's an open question of law, where the court should go. And so, one way to do that is to show, look, the Supreme Court in a neighboring state has addressed this same issue. They've got laws just like ours, and here's how they've addressed it. And so we think you should address it this way too. You can also use other forms of persuasive authority, such as if it was a state case, but there was a federal case on point, it wouldn't be binding on the state courts unless it was a federal case on a federal question. But if it was a federal case addressing a state law question, that would not be binding on the state courts, but would be persuasive authority. Other examples of persuasive authority are treatises, legal treatises, legal restatements of the law. So another type of precedent would be law review articles, legal journal articles, etc. So the fact that they go to Nevada, again, it's not binding on the court. But I thought, and that's fine. And that's something that we have to do as lawyers, to use persuasive authority when there's nothing on point. But the problem is, in my opinion, is that they used a case, first of all, which the main holding was not, the majority declined to reach the separation of powers argument. So this case didn't even address the separation of powers argument that was at issue in that case. But they go ahead and cite to some dissenting opinions that apparently say, okay, yes, this is clear. We can't have this, going on in our state where where we have a prosecutor also also acting as a legislator. So again, not binding. So the New Mexico court can decide to use that precedent from Nevada or decide to disregard it. They're not on any obligation to do anything with it other than consider it as persuasive authority. So I thought that was very interesting. So they go on to then argue kind of the last argument that you learn in law school, in litigation, is if you really have particularly a lack of binding precedent and you're kind of in this persuasiveness authority, et cetera, you always consider including a public policy argument. And so that's what they've done at the end of the motion here. And they basically are saying here is that, here's the concerns with separation of powers. And here's what we have a concern with, court. If you let this Ms. Reed, Representative Reed, that's smart, making their point, who has apparently touted her prosecutor expertise in connection with her promises to reform New Mexico's criminal laws, is legislating while also executing those very same criminal laws by prosecuting Baldwin. But he's already been charged. And anything that's charged, anything that is legislatively enacted prospectively would not apply to Baldwin. And we know that because, to be fair, they messed up. The prosecution messed up when they filed that enhanced gun charge against Alec Baldwin, the one that would have led up to 5 years, because that enhanced sentence charge was not enacted, I think was 7-8 months after the shooting incident. So she's not going to be able to, any laws that she votes on now are not going to apply to him. So, but this was what was really interesting, and I have no idea what they're talking about here. But he says that her potential influence on her colleagues in the legislature could thwart any efforts to legislatively foreclose a prosecution that has been widely criticized as unjust and unprecedented. Okay. Well, first of all, what does he mean by that? The legislature can't just now turn around and vote that Alec Baldwin is not guilty. They can't change the laws. He's been charged. That's it. That's the snapshot in time. They can't now the legislator come in and say, oh, we're not going to charge. We think this is wrong. And so therefore we as a legislature are not going to, we're going to change the law so he's not applicable laws to him. That doesn't even make any sense to me. Even if she recuses from votes on her own compensation. Now, the reason they're saying that is that because apparently for budgetary reasons, the first portion of the funding, I think, came from the executive budget. But in order to get additional resources, it's a funding thing. They had to ask the New Mexico legislature for that funding. So I guess the argument is that, well, she's going to decide her own salary for acting as a special prosecutor. And I mean, again, I think the argument was she obviously is not going to vote on that, would be conflict of interest, period. But in any event, they're trying to say that even if she recuses herself, her clout with her colleagues and other matters could, wittingly or not, encourage them to maintain funding for her position. I think that's a losing argument. It'd be very easy to recuse her and not have her part of some funding vote. I mean, on her actual. But and then they kind of go on and say that if the arrangement here were approved by the courts, future DAs could seek to curry favor with legislatures who control their budgets by appointing them to high profile cases, distorting the legislative process. So I guess what they're trying to say here, to be fair, is that they're saying, well, court, if you allow this situation with the special prosecutor to happen, then future district attorneys could try to like, hey, they want to get in good with some legislator who happens to also be a retired district attorney. We'll just I'm a district attorney and I really want to get in good with my legislator in my district, so I'm gonna like cede my authority as prosecutor and have them be a special prosecutor. And I mean, I don't know. I think that's where you go, like, it's gone a bit too far into the could it, I don't know. I think that's going a bit far, but in any event, it's an interesting argument that I think is more interesting than the simple salary matter. But in any event, the one quick thing I wanted to point out, and so they basically go on and just says that she would be biased. And that's kind of it. So we go to the district attorney's first argument, and they go through the New Mexico Constitution, which I'm going to pull up that up because I think there's a couple of things I want to point out for that. But in any event, we'll start here with the portion of the separation of powers section of the Constitution, which basically says here the powers of the government of this state are divided into three distinct departments. Remember, statutory wording is important. The legislative, executive, and judicial, and no person or collection of persons charged with the exercise of powers properly belonging to one of these departments shall exercise any powers properly belonging to either of the others. Okay, so pretty basic power balance, separation of powers argument. The DA concedes, of course, she's going to be considered part of the legislative because she was just elected as a legislator, right? So they're not arguing that. But what they do say is, first, she's not excluded because neither the DA nor the special prosecutor are charged with the exercise of powers properly belonging to either the executive or judicial departments. And what they say that they point out that I thought was a really good argument is they say the defense concedes that it's unclear whether the DA/special prosecutor is part of the executive or the judicial. So, but they come to the conclusion that that means, therefore, they must be one or the other, and therefore she must be disqualified. And what the DA says is the more logical conclusion, and what one that is supported by the text of the Constitution, is that they're not an actor of either of those two branches. So it's going to be a question of, are they part of, an actor of, possessing power of one of those three? And I thought that was really interesting. And particularly here, where they start into the constitutional argument, where they say that defense's argument seems to stem from the misconception that all government employees must be members of one of these three branches. But that's not how the state government structure is set up in the New Mexico Constitution, according to the DA. And so what the DA says is, look, we're going to go to the Constitution and we're going to show that it's set up in three distinct departments. And the Constitution shows who's in those departments and what are the powers of those departments. And again, of course, they say that. So, first, so here they start talking about what does his executive department say and who's part of that executive department. Executive department, again, consistency in language, the executive department shall consist of a governor, a lieutenant governor, secretary of state, state auditor, state treasurer, attorney general, and commissioner of public lands. I didn't see anything about a local district attorney or local special prosecutor in that list. So based on statutory construction, that's a good argument. I mean, based on the plain language of the statute or here the Constitution, this is it. If they would have wanted, and basically what the DA winds up arguing is, look, if they would have wanted to include these other entities like the DA or a special prosecutor of a DA, they would have put it in here. It's not. That's basically their argument of why the special prosecutor and the DA more broadly is not part of the executive branch. But then they go ahead and say, okay, so then if it's not part of the executive branch, now is it part of the judicial branch? And what is kind of weird in New Mexico is apparently DAs and public defenders. I mean, I guess it's not weird, but anyway, the way that it's structured in New Mexico is DAs and public defenders are established, the authority for those positions are established under the judicial department provision section of the Constitution. DAs and public defenders are established under the Article 4 as part of the judicial system. There is no argument that local prosecutors or public defenders are exercising judicial power of the state because they have no ability to render or enforce a judgment. So basically, and then they go on to say that for that reason, the New Mexico Supreme Court has all long recognized that DAs are, because they're part of the judicial system, they're quasi-judicial in nature, and they're not a judicial office. So I think that it probably would end that argument there, because I just don't see how you would argue that they would be part of the judicial, because again, the point of the judicial part of government is to decide disputes, right? Clear between these two, the motion and the response is that this is an open question in New Mexico. And I think it's going to be really interesting to see what the court does. Now, like good lawyers, if we don't think we're going to win on argument one, we always have a fallback. Now, in the defense's motion, I would say their fallback is their public policy argument. But here, the DA's office actually has what I think is a fairly decent secondary argument. And basically what they say is, look, even in the alternative, even if the court were to hold that Ms. Reed, acting as the special prosecutor, is exercising powers of either the executive or judicial, she still doesn't have to be mandatorily disqualified, as the defendant argues, because and apparently there's no authority on this precise issue, but generally speaking, this idea that there's this, very clear-cut division between the branches is not necessarily always the case for all situations in New Mexico. And what the DA cites here is that the New Mexico Supreme Court has long recognized in other contexts, again, not this context, so this will be persuasive as well. The court doesn't have to go along with applying this result in this case, but it's, again, the DA showing here's other situations where the court has held that we're not violating separation of powers simply because there's some overlap of governmental functions. And I think that, with the point of the DA being a quasi-judicial function, I think that makes sense to me. And then they further go on to say that the Supreme Court need only or this court, excuse me, need only intervene when a branch of government is unduly encroaching or interfering with one another. And here's where they make the argument: we're not going to encroach. There's no actual or threatened encroachment here. Um, you know, first of all, they don't allege that as a legislature, she's going to interfere with his prosecution. But the argument seems to be that because she's acting as the special prosecutor, excuse me, she might thwart a hypothetical attempt by the legislature to encroach or interfere with that prosecution. And again, this was where I was confused before. I was like, how is she, either by herself or by convincing her colleagues, going to do anything about this prosecution as legislatures? And then indeed, the DA says the defendant does not explain how the legislature could legislatively foreclose defendant's prosecution, or how it's, which I think is a good argument, or how such an effort itself would not violate the whole separation of powers argument that they're bringing. And in fact, they go on to make that argument. The legislature can't interfere with prosecutions. And so, and then they finalize with defendants' other arguments that Ms. Reed could unwittingly encourage fellow legislatures to continue funding the prosecution. The future district attorneys could curry favor with legislators by appointing them as special prosecutors, or special prosecutors could prosecute prominent defendants associated with an opposing faction within the legislature. I mean, this sounds like conspiracy theory to me. Are purely hypothetical and demonstrate the limb defendant must climb out in order to allege some sort of encroachment or interference. Disqualification of a special prosecutor on constitutional grounds is a severe remedy and cannot be supported by the imaginative but unsupported theories set out in defendant's motion. The state therefore respectfully requests the defendant's motion be denied. Like I said, I had so much fun reading both of these. I thought, both sides did a great job, and it's completely open, guys. So, what do you guys think? I think that both defendant's motion and the district attorney's response were both really well written. I think that the defense's motion was very interesting and I mean, great lawyering. But I think then the DA's response was great lawyering. So I'm super interested to see what the court does. I mean, it truly is an open area, an open issue. It has not been decided, and it's not clearly set forth in either the Constitution or the case law. So what do you think? I'll be sure of watching it. I know that there's going to be a status hearing Thursday today when I'm recording this, but I don't think they will have decided on that at that time, just because the state just filed their response earlier this week on Tuesday, I believe. So, but I will keep you updated. And in the meantime, breaking news, Rust update. So I'm going to share my screen and we're going to go over it quickly together. All right. So, Alec Baldwin evidence stunner. New Mexico destroyed gun used in Rust shooting. What? Actor Alec Baldwin's attorney told a judge on Thursday that the New Mexico government destroyed the firearm. Alec Baldwin's attorney: I think I should tell the court that the firearm in this case, that's a great subject of it, was destroyed by the state. So that's obviously an issue. And they'd like to see it, or what's left of it. Wow. That's a problem. Yeah. It was so this occurred today. They were having a brief status conference. So that's shocking. It looks like the defense didn't give much details of what it meant by being destroyed. So we don't have anything there. And it looks like the DA didn't dispute that. So that's going to be interesting. We'll have to see what goes on with that. And it's also unclear what the defense remedies they're going to seek for that. But in any account, an event, the other interesting thing is that they did say here that the judge has scheduled a hearing on that motion to the defense motion to disqualify the prosecutor that we just went through. That is now set for hearing on March 27th. So I will report back then. Thanks so much again for watching, and I hope to see you in my next one. Bye.